Greetings to all. Welcome to Future Officers Academy. Today we are going to see daily current affairs video of 23rd May. To get more daily current affairs videos, follow our YouTube channel. Now we'll move on to today important topics. Today we are going to see the topics of windfall tax, mutual fund and International Court of Justice. Windfall and mutual fund comes under GS3 paper and International Court of Justice comes under GS2 paper. Now we are going to see a detailed analysis of these three topics. The first topic is windfall tax. What is about this windfall tax? It is a tax levied by the government against certain industries when economic conditions allow those industries to experience significantly above average profits. Here, the term windfall refers to an unexpected rise in profit. So, and the tax on windfall gains is also known as windfall tax. Now, when it has been imposed, when the government notices a sudden increase in the industry's revenue, they impose this tax. These revenues cannot be linked to anything the company actively pursues, such as its business strategy or expansion. Rather, it is related to one of external event for which the business is not responsible. Also, a windfall tax is imposed on an industry profits when it experiences a sharp increase in revenue due to the unrelated external events. A recent example is the sudden rise in the profits of the oil and gas industries due to the Russian-Ukraine conflict. The unexpected windfalls are taxed by the government over and above the normal tax rates. The most common industries that fall target of windfall gain tax includes oil, gas and mining. Now, what is the purpose of this? It is redistributed of unexpected gains when high price benefit producers at the expense of consumers to fund social welfare schemes also as a supplementary revenue stream for the government, also as a way of for the government to narrow the country's widening trade deficit. So that's all from the windfall tax. Next, our topic is about mutual fund. Under this, we are going to see what is about mutual fund and the role of the trustees, their issues, and what SEBI have been recently proposed, and their benefits of holders and investors. So these are all the things we are going to discuss under this topic. So first, what is about this mutual fund? Indians have relied on real estate, gold and bank fixed deposits for their investments. In the last 2 decades, mutual funds have been emerged as an alternative and possible superior investment option because mutual funds offer an opportunity to earn higher returns compared to these traditional investments. Mutual funds offer easy access liquidity similar to the bank deposits, more straightforward exist, and remove investment management risk from the individual investor as the professional fund managers and manage them. Also, the mutual fund is an investment vehicle that pools funds from investors and invest in bonds, equities, bonds, government securities, gold, and other assets. Now, companies that qualify to set up these mutual funds create asset management companies or fund houses which pool in the money from the investors, market mutual funds, and manage investments and enable investor transactions. Mutual funds are managed by sound financial professions who are known as fund managers. And who have the expertise in analyzing and managing investments or these fund managers. The funds collected from the investors in mutual funds are invested by the fund managers in different financial assets such as stocks, bonds, and in other assets. The AMC charge a fee to the investor known as expense ratio. It is not a fixed fee and varies from one mutual fund to the another. Now, the SEBI, that is Securities and Exchange Board of India, has defined the maximum limit of the expense ratio that can be charged on the basis of the total assets of the fund. Now, what is the role of the trustees here? Mutual funds in India have a three-tier structure. That is mutual fund, the trustees, mutual fund, the trustees, and the AMC. So this is the three-tiered structure, and the board of trustees or trustee company holds the property of the mutual fund in trust for benefit of the unit and holders. They appoint an AMC to float schemes for the mutual fund and manage the funds mobilized under various schemes. Also, they expect to exercise a supervisory oversight over AMC. Now, what are the issues identified by the SEBI under this? According to SEBI, though mutual fund regulations provide for some restrictions to address few conflicts of interest, there are some areas where the trustees need to pay attention. Also, what are some of the potential conflicts include here? Investment by mutual fund schemes in public issues of its sponsor, it associates another group of companies. Sponsor influencing voting by mutual fund schemes in companies in which it has an interest and mutual fund availing services of its sponsor. Associates and group companies are terms which are not arm's length. Now, what SEBI have been proposed recently? It have proposed system level checks and to take help of audit, legal firms and merchant bankers. The third, amended the regulations. Next, unit holder protection committee. Next, convert into trustee committee. So these are the recent proposals that SEBI have been done. Now, what are the benefits that unit holders or investors they receive? SEBI said that increasing scale and reach of mutual fund industry trustees' role in respect of unit holders protection assumes even great significance. When finalized, the trustees will ensure that the AMCs act in a manner which is not skewed in favor of AMC stakeholders. The key areas of their focus will be fairness of fees and expense charged by the AMC and misconduct including market abuse, misuse of information by the AMC or AMC employees or the AMC distributors. The trustees will ensure that there is no mis-selling of mutual fund schemes to increase asset under management and valuation of AMC. Here, our next topic is about International Court of Justice. Under this, we are going to discuss about what is International Court of Justice and their functions and their composition. So, now what is about this International Court of Justice? So, the International Court of Justice is also known as the World Court, is the principal judicial organ of the United Nations. It was established in June 1945 by the Charter of the Union and began work in April 1946. The seat of the court is the Peace Palace in The Hague, which is in Netherlands. Of the 6 principal organs of the UN, it is only one not located in New York, United States. The hearings of International Court of Justice are always public. Their official language is French and English. Now, their powers and functions is the court may entertain two types of cases. First, it can act as a dispute settlement body between two member states in what are called contentious cases. Such disputes may concern in a particular land frontiers, maritime boundaries, territorial sovereignty, the non-use of force violation of international humanitarian law, and non-interference in the internal affairs of states and diplomatic relations. These are the first. And second, it can accept requests to issue an advisory opinion on a legal question referred to it by an UN body or an specialized agency. These opinions can clarify the ways in which such organizations may lawfully function or strengthen their authority in relation to their member states. The court judgments in contentious cases are final and binding on the parties to a case and without any appeal. Unlike the court judgments, advisory opinions are not binding. The International Court of Justice decides disputes in accordance with international law and reflected in international conventions, international custom, general principles of law recognized by civilized nations, judicial decisions, and the writings of the most highly qualified experts on the international law. Now we are going to see their composition. It consists of 15 judges, all from the different countries, who were elected to 9-year terms by majority votes in UN General Assembly and UN General Assembly and Security Council. Now the judges, 1/3 of whom are elected every 3 years, are eligible for re-election. Once elected, a member of the court is delegate neither of the government of his own country nor of any other state. The Chief Justice, in International Court of Justice statute allows a state party to a case before it which does not have the judge of its nationality on the bench to appoint a person to sit as a judge ad hoc in a specific case. The court is assisted by the registry, its permanent administrative secretariat, which is independent of United Nations Secretariat. So that's all from our today's topic. To read this document, you can visit our website. The website link have been given in our description. To get more daily current affairs videos, follow our YouTube channel, also our Telegram channel. Thank you.